A sponsor asks, can we use an old LLC for this new property? This is Syndication Attorney Field Notes. I'm Tilden Moschetti, a syndication attorney. Today's field note is about the single purpose entity in a Regulation D private placement for a real estate syndication or an investment fund capital raise. The question sounds like filing fee housekeeping. It is not. Once you have an asset level LLC, lender covenants, and entity separateness, the old LLC shortcut can change the legal and lending picture. The plain English answer is this. A single purpose entity, or SPE, is a tightly restricted LLC built to own one asset and do nothing else. It is not a flexible business entity. It is a clean box. One property, one commercial mortgage, one bank account, one set of books, one permitted role. So can you use the old dormant LLC? Usually that is not the right answer. The better structure is a clean entity formed for that property with no other business in its past or future. In a single property syndication, the investor-facing entity may also be the SPE. In a multi-asset fund, the fund usually handles the investors and the offering documents. Each property then sits in its own asset level LLC that owns the building and signs the loan. That is the basic map. The common sponsor mistake is treating every LLC as if it is the same. I understand why that happens. State filings make LLCs look simple. You file a form, you get a name, you open a bank account. So when the next deal comes along, the thought is, why not reuse what we already have? The problem is history. An old LLC may carry old risk. Maybe there was a vendor bill. Maybe a contract was signed. Maybe there was a property tour, an unpaid invoice, a tax notice, or a deal that died but left a loose end. The lender cannot always see that history, and the lender does not want to underwrite it. A clean new SPE gives the lender a clean box to underwrite. That is why many loan documents ask for a newly formed entity with no prior operations. The lender wants the property securing this loan to sit by itself. The same mistake shows up another way. A sponsor starts buying more properties and says, can we just put all three buildings in the same LLC? It would be easier. It would be easier on the first day. It may not be easier when one property has a claim, a loan issue, or a cash problem. The distinction that matters is role and restriction. A normal LLC is built for flexibility. It can run a business. It can hold different assets. It can take on new projects. That flexibility is the point. An SPE is built for limits. Its job is narrow. Own this asset, manage this asset, carry this loan. Do not guarantee another deal. Do not pledge this property for another property. Do not mix the books. Do not use the bank account as a shared wallet. That is what lender covenants are about. A covenant is just a promise. In this setting, it is a promise that the SPE will stay in its lane. Entity separateness means you treat each legal box as its own business, not just on the chart, in the bank account, in the records, in the contract, in the signature block. In a real estate fund structure, the roles usually separate into three boxes. At the top, you have the sponsor entity. That is the management company. It manages the deal or the fund. In the middle, you have the investment entity or fund. That is the investor-facing entity. It pools investor capital in the Regulation D private placement. It gives the private placement memorandum or PPM. It signs the subscription agreements. That is the securities side of the structure. At the bottom, you have the asset level LLCs. These are the SPEs. Each one owns one property. Each one signs its own commercial mortgage. Each one faces its own lender. That separation matters because the lender and the investors are not looking at the same risk in the same way. Investors are looking at the offering. They want to know what they are buying, what the fund can buy, and how their money will be used. The lender is looking at collateral. It wants to know what building secures this loan, what entity owns it, and whether that entity has other debt or other business. So the structure keeps investor capital and commercial debt in separate lanes. Here's a quick example. A sponsor raises capital through one Regulation D real estate fund to buy 3 apartment buildings. The fund takes investor subscriptions. The fund gives the PPM. The fund is the entity the investors own interests in. Then the fund forms 3 asset-level SPEs. SPE owns Building A. SPE B owns Building B. SPE C owns Building C. Building A has its own bank account. Building B has its own bank account. Building C has its own bank account. If Building A has a tenant lawsuit or a loan workout or an insurance dispute, the design is that the problem stays in Building A's box. It is not supposed to spill into Building B and Building C just because the same sponsor is behind all 3. But that only works if the sponsor acts like the boxes are real. Separate accounts, separate records, correct signatures, contracts signed in the right capacity, no moving cash back and forth without clean paperwork. This is where entity separateness becomes practical. It is not just a phrase in the loan documents. It is how you operate on a regular day. Now, a few things not to assume. Do not assume an old dormant LLC is clean enough for a new real estate syndication loan. It may be, it may not be. But the point of a newly formed SPE is to remove that question. Do not assume the asset level SPE is always the same entity that deals with investors. In a single property deal, it might be. In a multi-asset fund, it often is not. The fund handles the investor side. The SPE handles the property and the loan. Do not assume a bankruptcy remote entity means no bankruptcy can happen. It means the entity has been structured to reduce the chance that one property gets pulled into a larger sponsor problem. It is a design point. It is not a promise that no court process can ever occur. Do not assume separate entities protect you if operations are sloppy, if the same account pays every expense, if the wrong entity signs contracts, if records are missing, the structure is weaker than it looks. And do not assume a non-recourse loan removes all personal exposure. Many commercial loans include bad boy carve-outs. That means the lender may have personal claims if there is fraud, misuse of rents or deposits, or an improper bankruptcy filing. The SPE protects against normal deal risk. It is not cover for bad conduct. So when a lender sends you SPE covenants, read them as a map of what the lender is trying to protect. The lender wants one asset, one loan, one borrower, and one set of clean records. It does not want the building tied to your other projects. It does not want this SPE guaranteeing another property's debt. It does not want this bank account used as a common pot. And Securities Counsel is looking at the other side of the same problem. Who took the investor money? What did the PPM say the money would be used for? Which entity did investors buy into? Which entity owns the asset? Which entity signed the mortgage? When those answers are clean, the deal is easier to understand. When those answers are mixed, the deal becomes harder to explain to lenders, investors, and anyone reviewing the file later. Final field note. The single-purpose entity is not just another LLC. It is scaling infrastructure for a sponsor building a portfolio. Think one asset, one loan, one clean roll. The SPE gives the lender a clean box to underwrite. It helps keep investor capital and commercial debt in separate lanes. It helps one property problem stay with that property. But the structure only helps if you operate it with care. Separate books, separate bank accounts, clear records, sign in the right capacity. Keep each entity in its lane. The protection follows the discipline.